Good evening. I want to call together our Planning and Zoning meeting for October 21st, 2013. And the first order of business is roll call. Madam Secretary.
Ms. Protos? Mr. Parker? Mr. Carr?
Here.
Mr. Stavropoulos? Mr. Gialusis? Ms. St. Arnold?
Here.
Mr. Vinson?
Here.
Chairman
And
Francis?
Chairman. Here. Okay, at this time, we're going to have the quasi-judicial announcement and swearing in of speakers by our attorney, Tom Trask.
Yes, Mr. Chairman, board members, if everyone could listen up, I'm going to go ahead and read through these procedures. This is a quasi-judicial proceeding where the Planning and Zoning Board acts in a quasi-judicial capacity. By law, it's the board's function at this hearing to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application in the applicable code sections. If that evidence demonstrates that the applicant has met the criteria established in the Code of Ordinances, the board is required by law to find in favor of the applicant. By the same token, if the evidence demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinances, the board is required by law to find against the applicant. The parties to this hearing are the applicant and the city. The city is represented by city staff. There may be persons, organizations, or groups that qualify as interveners. Persons or groups that qualify for intervener status can participate in the hearing as a party. A recognized intervener may examine witnesses, present evidence, and make arguments to the board. For a person to be granted intervener status, the person must demonstrate to the board that he or she will suffer an adverse effect as a result of the quasi-judicial decision which exceeds in degree that which may be suffered by the general community. Intervener status may be granted to the representative of an organization or a group of persons who have a substantial or compelling interest in the matter under consideration if the organization or group of persons can demonstrate that it is prepared to present competent and relevant evidence which would be of significant assistance to the board in making its quasi-judicial decision. In a few minutes, the chairperson will give persons, organizations, or groups desiring intervener status the opportunity to make their requests. There is an established procedure which will be followed at this quasi-judicial hearing. All witnesses must give their testimony under oath. All persons testifying at this hearing must give their name and address for the record. All testimony and questioning at this hearing must address matters that are relevant and material to the issues under consideration. The city staff will present its testimony and evidence first. The applicant and recognized interveners will have an opportunity to cross-examine the city staff and any city witnesses. The applicant will then present its witnesses and evidence. The city staff and recognized interveners will have the opportunity to cross-examine the applicant's witnesses. Recognized interveners will then present their evidence and witnesses. City staff and the applicant will have the opportunity to cross-examine the interveners' witnesses. Absent unusual circumstances to be determined by the board, a party's opening statement and presentation is limited to 10 minutes. At that point, we will proceed to the public comment portion of the meeting. Members of the public opposing the application will be given an opportunity to present testimony. After all members of the public opposing the application have concluded, members of the public in support of the application will have the opportunity to present testimony. Each member of the public is limited to 4 minutes of testimony. A member of an organization or group granted intervener status who testifies as part of the organization or group's presentation forfeits the right to speak during the public comment portion of the meeting. During the public comment portion of the meeting, members of the public present at the hearing may donate their time to a speaker to extend the speaker's time. But in doing so, the person donating the time forfeits his or her right to speak. Each donation shall extend the speaker's time an additional 2 minutes. In no event shall the speaker's time be extended beyond 10 minutes of total speaking time. Following the public comment, the applicant, city staff, and recognized interveners will have the opportunity to present rebuttal evidence and make a closing argument or summary. The applicant will go first, followed by city staff and any interveners. Absent unusual circumstances to be determined by the board, a party's closing summary and rebuttal evidence will be limited to 10 minutes each. Following this, the board will consider the matter. Now, with that being said, anyone that's going to testify today, if you could stand, raise your right hand, and you'll be sworn under oath. Anyone that's going to speak tonight. Do you swear or affirm the testimony that you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you, Mr. Trask. The first order of business is application 13-62, Tarpon Place North, and we will hear from staff.
Mr. Chairman, the applicant has requested that we skip over the first two items because their consultant is running a little late, so they would like for us to consider application 13-64 first, give him some time to get here. So if the board doesn't object, I'll go ahead and give you the remarks for application 13-64, the conditional use for the School of Special Education.
Okay, can we just have a general agreement then, or do we have to bring it to a motion and a vote?
No, you have that right to do that, Mr. Chairman. You don't need
Okay.
to do anything.
Okay, thanks. All right, we will entertain now 13-64, Layman.
Thank you, Mr. Chairman. Again, this is a conditional use application for School of Special Education at 528 East Tarpon Avenue. The property is located in a residential office zoning district, and the applicant wishes to establish a scuba instruction and certification school at this property. And due to the nature of this use and the definitions contained in the Land Development Code, conditional use approval is required. Under standards for review, criteria 1 deals with the conformance to the requirements of the Comprehensive Zoning Land Development Code. And as you can see, the code requires 6 off-street parking spaces for a building of this size with this type of use. The applicant has just provided me a copy of a cross-access easement between the two adjoining property owners that satisfies this request. As you see in my remarks, there are at least 15 spaces in the parking area that exceeds the amount of parking that's required for both of these types of uses. So our determination is, with the introduction of the easement, it does meet this criteria. We've also determined that there are no issues with compatibility, that the use is consistent with the city's comprehensive plan, that there will not be any adverse impacts on environmental or historical resources, that this proposed use would not have any negative impacts on property values, nor would it impact the city's ability to provide the appropriate public facilities, and that it would have a positive impact upon the growth patterns on this area of the city. TRC reviewed the application at the September 26th meeting, and you have the comments in your staff report. We have properly noticed the application and have not received any calls, letters, or emails on this item. As far as the staff recommendation, it's our opinion that the applicant's request has met all review criteria. Therefore, our recommendation is to approve the conditional use for a School of Special Education at 528 East Tarpon Avenue with the following condition, and that is that the retail sales be limited to merchandise and equipment that is accessory to the primary uses of the property, for example, scuba equipment, weights, and so on. And you have a couple photographs of the building looking south from Tarpon Avenue. You have a location map, an aerial photograph, zoning map, future land use map, as well as a supplement prepared by the applicant and a boundary survey of the property. Are there any questions?
Okay, I forgot to ask, is there any ex parte communication relative to this application by any board member? Okay. We'll start. Jacob, you want to go ahead? If you have any questions.
The only question I have is number 2, the retail sales must be limited to the merchandise. Is that typical in
Yes.
what we do with on the board? I mean, can it
and
sell
I'll-
bottled water, or I mean,
It has everything to do with the future land use plan category for this particular property. It's a residential office general category, which severely restricts retail uses. By its very definition, it's limited to residential office and those types of uses. So the use of the property in a limited retail fashion, as we've conditioned it, would not violate the requirements in the future land use plan.
okay, how's that enforced? just, we just say that's the way and then,
Yes.
okay, fair enough. Thanks.
Anything else?
That's it.
Mr. Vincent?
Rodney, I have a question about, I noticed that the applicant for the conditional use is the current owner, and they have a contract pending, and it's the proposed buyer who wants to use the facility or the building in this, for this conditional use. What were to happen if, for some reason, the sale didn't go through, if we approved the owner's application for this conditional use, and for whatever reason, if the sale doesn't take place and the use doesn't, it's not used in that fashion?
If the use is not established within 12 months of the approval, then the conditional use expires, and then it reverts back to only those uses that are allowed as permitted uses in the district.
How would that affect the current use as, I mean, if the sale didn't go through?
Right. It can still be utilized as a real estate office because
It's
that's a
still-
permitted use in that district.
Thank you. No further questions.
Okay. Ms. Arnold?
No, I don't have any questions. Thank you.
I don't have any questions. We'll hear from the applicant.
Yes,
Mr.
Michael
Kuskudis.
Kuskudis, 623 East Tarpon Avenue. I'm here for the applicant. The supplement that was provided in your package sort of has a pretty good explanation as to what the intended use is for. With regard to the limited retail, it's hard not to provide a service if somebody's coming in, whether it's, a dive to buy, a mask or fins or something like that, not to be able to provide them for them. And as the application says, this, the proposed purchaser of the property, they're dive masters. They've been operating the Narcosis, if you know where that is, the Narcosis dive shop, and they're looking to better improve the quality of their instruction and open it up. They're sort of limited in space where they're at now. I think this will enhance that property. They get people from all over the Tampa Bay area who come for dive classes. They run their chartering business out of there for dives. They actually charter dives all around the state of Florida and in some places out of the country. That's one of the things that they do. They'll organize in their offices. As you can see, obviously it'd be subject to whatever the codes require. The long-term intent is to put a pool to enhance their opportunity for dive instruction on the premises. So I'm here to answer any questions that you may have.
Okay, thank you. We'll start with Mr. Carr.
I don't have any questions. Thanks.
Mr. Vincent?
Well, I don't know if this is for Mr. Kuskudis or for Rodney. The aspect if the owner was to want to put in a pool for in-water instruction, what would that require as far as approvals or permits?
Just a building permit. We've been in contact with their engineer on the mechanics of that, so there'd be no other further board approvals that would be required to issue the permit for the installation of the pool.
They wouldn't need a site plan for
No.
making that change?
Ms. Arnold?
No questions. Thank you.
Okay, I don't have any questions. Anything else, Mr. Kuskudis?
No.
Okay, have a seat. Is there anyone in the audience who wishes to speak against this application? Is there anyone who wishes to speak for it? Hearing none, I'm going to close the public portion and entertain a motion for this application.
I'll make a motion that we accept application 13-64 Lehman as it stands.
Second.
Okay.
Just for clarity's
Ty,
sake, I want to
between-
make sure, Chairman, that it's with regard to approval of the staff recommendation. Is that the motion?
Okay,
Yes.
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 Yeah,
Okay.
yes.
Sorry.
Okay, any other discussion? Okay, have a roll call.
Mr. Carr?
Yes.
Ms. St. Arnold?
Yes.
Mr. Vincent?
Yes.
Chairman Francis?
Yes.
Good luck.
Yeah, it'll be on November 5th.
Okay, Mr. Rodney, do we move on to the next, is there still somebody that we're waiting for? Or?
Okay. All right, so we're ready. Okay, this is item number 3 on your agenda, application 13-62. Tarpon Place North is a conditional use application for an affordable housing density bonus, parking reduction, and 25% setback reduction to be applied to .381 acres of property at the northeast corner of South Gross Avenue and East Boyer Street. This application is somewhat similar to the others that the Housing Authority has brought to this board in the past. Just last week, the Housing Authority was commended on their Oak Ridge Estates project. I don't know if many of you guys saw that, but they received the Better Community Award from the 1,000 Friends of Florida for their Oak Ridge Estates projects that you may recall came before this board a few years ago. And I'll just read a quote from their president. And kind of what he said was that Oak Ridge Estates provides an outstanding model for communities seeking to promote infill, affordable housing in older and historic neighborhoods. It meets a critical community need in an architecturally compatible and sustainable manner. And that was presented to the City Commission, or at the City Commission meeting on October 15th. And these next 2 applications will carry forward in that same vein. If you want to go to the bottom of page 2, just to kind of highlight the specifics of the proposal, the property is a little over 1/3 of an acre, and they would like to construct 8 rental units on the property. All of those units will be affordable per the city's definition, and the Housing Authority will own and operate the development. You have in your packet a report from the Housing Authority that includes the funding mechanism, the proposed ownership and management structure, and a conceptual site plan. The applicant is requesting an increase in the residential density from 15 dwelling units per acre to 21 dwelling units per acre, and a parking reduction from 14 spaces to 9 spaces, and a 25% reduction in the building setbacks. As far as standards for review, we have determined that the request for the bonus density, the reduction in off-street parking requirement, and the reduction in setbacks could be done in a way that conforms to the Land Development Code. Specifically, the reduction in setbacks allows for the establishment of a courtyard between those units that could serve as a central gathering place. The reduction in off-street parking spaces should not be an issue because the units are primarily 1- and 2-bedroom units. Furthermore, there's public transportation in close proximity to the site. And lastly, as with all our density bonus applications, the applicant has agreed to execute the agreement that binds them to those affordable housing criteria. You see that in your staff report. We've also determined that the use is compatible with the existing and planned uses in the area. It's consistent with the comp plan. There should not be any adverse impacts to environmental and historical resources. It will not have an adverse impact on adjoining property values. It will not impair the city's ability to provide public facilities, nor will it have a negative impact on growth patterns in this area of the city. The TRC comments are listed there in your staff report. You'll see at the end that all the comments that we had as a committee were addressed in the September 25th resubmittal. We did properly notice the application and have not received any correspondence to date. It's our opinion that the applicant has met the review criteria. Therefore, the staff recommendation is to grant the affordable housing density bonus from 15 dwelling units per acre to 21 dwelling units per acre, reduce the required off-street parking from 14 spaces to 9 spaces, and reduce the setbacks by 25% for the property at the northeast corner of South Gross Avenue and East Boyer Street in the RM15 zoning district, as depicted on the applicant's conceptual site plan with the following conditions. One, the applicant must execute a recordable agreement in a form acceptable to the city, binding upon the developer and subsequent purchasers, successors, and assigns of the developer that A, requires that the development continue to comply with the affordable housing criteria set forth in this article for a period of 30 years. B, provides for penalties to be imposed on the developer and subsequent purchasers, successors, and assigns of the developer if the development fails to comply with the affordable housing criteria set forth in this article for a period of 30 years. C, provides for legal recourse by the city against the developer and subsequent purchasers, successors, and assigns of the developer if the development fails to comply with the affordable housing criteria set forth in this article for a period of 30 years. D, provides that the city may audit or review the books and records of the developer, subsequent purchasers, successors, and assigns of the developer and any person or legal entity operating the development on behalf of the developer or subsequent purchasers, successors, and assigns of the developer in order to determine whether the development is in compliance with the affordable housing criteria set forth in this article. E, in the case of a rental housing development, provides criteria for screening renters based upon their rental credit and employment history, their income, and the possession of a valid verifiable Social Security number or valid verifiable work visa, alien registration receipt card, temporary resident card, employment authorization card number, or other identification verifying eligibility to reside in the United States. And F, in the case of a rental housing development, provides that tenants may be evicted if determined to have engaged in any unlawful activity. We have a location map, an aerial photo, a zoning map, the future land use plan map, a conceptual site plan, as well as a written description of the proposed use prepared by the applicant. And you also have a series of photographs of their previous projects, which demonstrates the architectural style of the units that will be constructed if the conditional use is approved and the project receives tax credit funding.
Yeah, thank you, Rodney. Questions for staff? Start with Mr. Carter. If you have any questions.
Sure. Rodney, the one question I have here is, it says an unimproved alley. Is that, no, that's going to run right off Gross Avenue down the side of the property. What is that alley? Is it grass or, I mean, I can't tell from the picture really.
Yes, if you look at the aerial, you'll see that it's an unapproved alley that runs the length of the block.
So what does it consist of now? Is it just
It's grass.
dirt, grass? So they'll be driving in probably on some type of grass.
There's a second component to this. If the project is selected for funding, then they have to come back to us for a site plan approval, and that's when they'll have the details for the improvements to be made to the alley. So most likely it'd be a sub-base, a base material, asphalt, and so on.
Okay, so right now we're just going, it doesn't
With the
have
use
any.
of the property.
Okay.
Correct.
Okay.
If there, okay. Go ahead, sorry.
And then I don't know if this question's for yourself or it should be for the applicant. Affordable housing, what do you think the average vehicle per dwelling unit is for affordable housing? I know you guys said it meets criteria for, is that an applicant question or is that a question that you would?
It's probably better for the applicant.
Okay. I'll wait for that then. That's all I have right now. Thanks.
Just for clarification, the conditions that are referred to in my staff report refer to the criteria contained in Article 4, which is Section 71 in the Land Development Code.
Thanks for clarifying that.
The, Rodney, on that alley, would, if somebody was adjacent to this, would they still have access to their property?
Yes.
Okay.
Yeah, that was one of our discussion points at TRC, was making sure that the alley would be maintained in such a way that it was usable to anyone who who abuts the alley.
Okay. Mr. Vincent?
No questions. We've done several of these before in the past, and I don't have any questions. Thank you.
Mr. Arnold?
I don't have any questions either. Thank you.
Okay. We'll hear from the applicant. Please come up and give us your name and address, please.
Rich O'Dre with Avid Engineering.
You want to speak, you want to pick up the mic. It will come off of there.
Oh, okay.
Just Yeah, there you go.
Rick Joe Dre with Avid Engineering, 2300 Curlew Road in Palm Harbor. I'm standing in for Pete Penza tonight. Mr. Chapman has fairly well described the project. As said, it will go through a full site development plan, at which time the design for paving, so on and so forth, as well as building permit on the buildings themselves. If you have any further questions about the engineering
A little closer.
or any other aspect due to the engineering, I'd be happy to answer that. And I think Pat has an answer about the parking, potential parking
Pat.
required.
Pat Weber, Executive Director of the Housing Authority. What was your question about the parking? I didn't hear it over there.
I guess ultimately you've worked with many affordable housing projects in the past. What is the average vehicle use per dwelling in affordable housing units? I know it could range from...
With our affordable housing, with our public housing, I wouldn't say it's one car per unit, because if you go around our parking lots and look, there's a lot of empty spaces. I know, that's all I can say. I don't know that there's an average, but you're talking about people with very, very low incomes that can't afford cars.
Yeah, I understand
I mean,
that.
the average rent that we have is $147. So,
Okay, thanks.
Mr. Vincent, do you have any questions for the applicants?
No, I don't have any questions. Thank you.
Mr. Arnold?
I don't have any either.
Okay. Is there anyone out there who wishes, you want to speak against the project? Against it? Okay. Come up to the microphone and let us have your name and address, please.
My name is Joseph L. Marix. I reside at 517 East Boyer Street in Tarpon Spring. And I own the property next door to where they're building or requesting to build and stuff. Okay, my problem is, you know, they can build it. That's up to them. Well, I have an issue with the housing authority for the house the property that they built on Morgan and Gross, the elevation that they pull, and it floods all the property behind that, and nothing have been done to it today. And every time it rains, even though Swiss Mud approved a drainage system, but it's not adequate. It cannot hold the water, and when it rains, it floods the property and the houses. And they've been doing that ever since they built it. So I don't want this to happen to my property. So that's why I'm here. And I also would like to request that I don't want any trespassing on my property when they're building it, to make sure that they don't trespass on my property. I don't want anybody on my property parking or whatever. So that's my beef with it. And the alley, they say city haven't did anything to that alley in 30 years. It's all grown up and stuff, but now they say they want to maintain it now, but that's up to them. But all I'm saying for the records, that I don't want anybody on my property when they're building whatever they're gonna do. Let them do it, but don't do it on my property. And my last question is, I want to know what they're gonna do with the water, because the water flows down the alley from the east to the west like a river now, and the house next to my property floods at that as it goes. So my question is, what are they going to do with the water? They're going to do the same thing that they did to Morgan Street?
Just hang on a minute. Rodney, is that something that is going to be addressed when we have the site plan?
Sir,
Yes.
if
Yeah,
you wait
stay
up
there.
there,
Just stay there a minute, sir.
Yes, on the site plan, you would have details on stormwater ponds, the size of the pond, the depth of the pond, the design criteria, all those requirements, not only the city's requirements, but the Water Management District's requirements would be met. If you have issues about stormwater existing conditions now, I recommend you call the city's Public Services Department, and they should be able to help you out with those sorts of issues.
They haven't. So that's an old story. So it's still in litigation. But, you know, all I want them to do is not flood my property or my neighbors, because that's what happened to the project on Morgan Street. And they changed the elevation by 3.5 feet. Now all the water comes in on all the property around and floods it every time it rains, especially if 2 or 3 days rain. It's monsoon. It's flooding everything, look like a pond, and it's terrible. And I don't want that to happen to my property up on Boyer Street. That's my concern. Can build what they want, but take care of me. You know what I'm saying? And that's what I have to say.
Okay. Rodney, that's at the site plan time. I mean, that would be something that would be taken into account then. Okay, is there anybody who wishes to speak for this project? Okay, hearing none, we'll close the public portion and entertain a motion for application 13-62, Tarpon Place North.
Mr. Chairman, I move to approve application 13-62, Tarpon Place North. I'm sure that, well, I hope that the city, and when it comes to before the board in the site plan review, that we will be sure that they have adequate preparations to hold the water to address Mr. Merrick's concerns about the runoff of the water and also the condition of the alley.
Second.
Okay, we have a motion and a second. Discussion?
And just for clarity's sake, I want to just make sure again that Mr. Vincent's motion includes staff recommendation, or whether it's just an approval of the application, because that's an important.
I'm sorry. Thank you, Mr. Trask. Yes, the motion does include all of the staff recommendations.
Thank you.
Okay. Do we need to add anything regarding site plan, or that we just come at the site
Comes
plan?
back to us.
Okay, any discussion? Roll call.
Mr. Carr?
Yes.
Ms. St. Arnold?
Yes.
Mr. Vincent?
Yes.
Chairman Francis?
Yes. Okay, thank you. We will now move on to application 13-63. Mr. Chapman.
Thank you, Mr. Chairman. This is another conditional use submitted by the Housing Authority for an affordable housing density bonus, parking reduction, and 25% setback reduction for .488 acres at the northwest corner of South Gross Avenue and East Lime Street. Again, this property is in the RM15 zoning district. It's very similar to the previous application. I'll go ahead and go through the criteria. The current density of the property is 15 dwelling units per acre. The applicant is requesting a density bonus to go up to 16.4 dwelling units per acre. Again, if it is approved, the applicant will make application to the Florida Housing and Finance Corporation for tax credit funding for the project. Their reduction in off-street spaces is from 14 to 11, and again, the same rationale as far as the number of 1- and 2-bedroom units and its proximity to public transportation went into our analysis. And again, the applicant has agreed to record an agreement that establishes those criteria that you see there in your staff report to solidify the affordable housing aspect of the development. Again, we found this use to be compatible with the existing and planned uses in the area. It's consistent with the city's comprehensive plan, would not have any adverse impacts to the environment or historical resources, should not adversely affect adjoining property values, nor impair the city's ability to provide the proper public facilities, nor will it have a negative impact on growth patterns in this area of the city. Again, you see the TRC comments there from our September 12th meeting. And again, all our comments were addressed in the 9/25/13 resubmittal. Again, we have properly noticed the application and had not received any public correspondence. Therefore, the staff recommendation is to grant the affordable housing density bonus from 15 dwelling units per acre to 16.4 dwelling units per acre. reduce the required off-street parking spaces from 14 spaces to 11 spaces, and authorize a 25% setback reduction for the property at the northwest corner of South Gross Avenue and East Lime Street, subject to those conditions you see there in your staff report. Again, you have the location map, the aerial. Again, this is just south of the location of the previous application. You have a zoning map, a future land use plan map, a written description, conceptual site plan, a written description of the proposed use, and photographs of the architectural style of the units to be constructed. Oh, any questions?
Okay, we'll start with Mr. Carr.
My only question was, is it typical to go with 16.4, like always a fraction, or is it a whole number? I mean, it sounds kind of funny to do that.
It's a fraction. That's
It's
because,
just-
again, they want to build the identical building on this piece of property. So it's slightly larger than the other piece, so the density works out to be 16.4 units per acre.
And is that just typical in the building industry
Yes.
for
Mhm.
zoning? Okay.
Yes.
Okay. Everything else looks fine. Thanks.
Mr. Vincent.
Just to tag on to that, I think it's more just a calculation that it ends up that way.
Right.
And that's how it comes with a weird number, 16.4.
Yeah, I noticed the calculation. It's
Yeah,
just
right. No, I don't have any questions. This is pretty much the same as the other project, and so I have no questions. Thank you.
Okay, Mr. Arnold.
I don't have any questions, thank you.
Okay. Okay, I think this is very similar to what we've, almost identical, different locations, same idea. I don't think there's anybody out there against it. Anybody want to come up, speak for it? If not, I'm going to close the public portion, entertain a motion to accept the application.
I'll make a motion that we accept application 13-63 with the conditions as they're listed, A through F.
second.
Discussion? Roll call?
Mr. Carr?
Yes.
Ms. St. Arnold?
Yes.
Mr. Vincent?
Yes.
Chairman Francis?
Yes. Okay. This is going to go, Pat, this is going to go into that lotto thing again?
Yeah.
Is that going to go into the lotto? Same thing, all right. Well, I hope you get it. When? Oh, okay. Well, I hope it comes through, yeah. Okay, you guys are, good luck.
Good thing.
Okay, and the stage is now set for Mr. Chapman.
Thank you. As we talked about at last month's meeting, what you have before you for discussion and direction purposes is a couple alternatives for ordinance language to be forwarded to the City Commission on some criteria that regulates exterior or outdoor lighting. As you may recall, Mr. Vincent had forwarded staff some information on a model lighting ordinance developed by the Joint International Dark Sky Association and Illuminating Engineering Society. And this went to the board as a discussion item in May. And I think board as well as the staff was generally supportive of the concept, but there were some questions or reservations on the scope and the applicability of the new lighting standards. What I've gone ahead and done since that time is talked to a few people and researched other exterior lighting ordinances. And what you kind of have there in your backup is two draft ordinances. The first one, and it's identified as option 1 in your backup, is the ordinance developed by the International Dark Sky and Illuminating Engineering Society. That model lighting ordinance, as recommended by Mr. Vincent. Some of the specifics of that particular ordinance, it actually would be considered somewhat of an overlay to your zoning because there would be a map that would have to be adopted with that type of ordinance. It breaks down municipalities' areas into different lighting zones, and there are intensity limitations based on what the particular zone a piece of property is in. It has a different, a specific rating system for luminaires, which again is intended to control unwanted light. Both of these ordinances, if adopted, would go into Article 9 of the city's Land Development Code, which deals with development standards. The second ordinance, which is shown as option 2, is an outdoor lighting ordinance that is based on language from research of several other exterior lighting ordinances around the country. The majority of this ordinance would only apply to new commercial and industrial and multifamily developments in excess of 50 dwelling units. The ordinance contains a lighting plan submittal requirement as part of any new site plan review process, as well as maximum illumination standards for projects that meet that criteria. There is also an allowance for the use of the joint IDA-IES model lighting ordinance as a basis for an alternative lighting plan. That's something that I saw that was incorporated into the City of Orlando's exterior lighting ordinance. So they allowed for the ability to use the IDA-IES model if that was desired by the staff or the applicant. Again, these options are presented to the board for discussion purposes, and based on what I hear tonight, we as staff may make some revisions and then take those to the Board of Commissioners to see if they are or will authorize us to move forward with incorporating these new standards for lighting into the Land Development Code. So with that, I kind of want to hear from the board to see what your thoughts are.
Okay, this is just discussion right now.
Yes.
Yes.
Okay, all right. There's a lot of information here, and we've have had this several times. And this is probably new to Mr. Carr. Have you seen this before, anywhere?
I haven't seen
This material, but before tonight?
No, not.
I mean, before, after you read it, I know you read it and all that, but I'm just wondering.
You mean
Is this a
detail,
new-
like how
yeah,
much it
is
is?
this a new language to you?
Yeah, I mean, I've dealt a little bit with the Historic Preservation Board, but not as much. The lighting space seems like it's really overly detailed, so.
Say it again?
It seems like it's overly detailed in the option 1, but yeah, I mean, I've seen similar languages in the Historical Preservation Board still.
Okay. Rodney, I think you've incorporated actually option 1 into option 2 anyhow, regardless in the TRC. But now, I read this, but doesn't this also apply to homes on option 2?
The model ordinance, option 1 would apply. And option 2 does as well as far as light trespass. Let's say you have a neighbor whose light
Right.
extends over the property line into your area, then that is a code violation per se, so.
Oh, okay, I mean, that would be covered then?
Yes.
I mean, if they have a big light and it goes right into your
Floodlight,
house,
Right.
that would be covered. Now, do they, I haven't seen any outdoor spotlights that have this cover on them. I haven't,
Shields.
do they make them?
Shields, yes.
Shielding, yes.
Oh, and let me add, just thought about one other thing. I know there was a lot of discussion about the LED sign that was in the downtown. Option 2 kind of takes care of that. If you look at the restrictions,
Yeah.
it prohibits.
Yeah, I think that's a good idea because that's come up several times.
Right. Fortunately, the guy got rid of it, but
It's in there, yeah.
so yeah, that's in there as well. But Mr. Vinton, I'd like to know what you think about what the material is.
I thank you for bringing it to us, Rodney. But to correct, in the background information, you said earlier this year, the idea was brought up. It was actually July of last summer that I first contacted you, and you promptly notified the other board members of this concept of developing an ordinance for our city based on possibly the model ordinance by the International Dark Sky Association. And I have had a chance to review. I haven't had as much time to review these as I would have liked, but I've reviewed option 1 and option 2. I like the way option 1 is structured as an overlay, so that different areas of the city, depending on the types of uses and the types of neighborhoods, would have different levels of outdoor lighting that would be appropriate. But there's also some things in option 2 that I do like, but they can either be incorporated in a separate ordinance and that sort of thing, such as the impact on traffic. When you have offensive lighting that is a glare or it poses a hazard to traffic or pedestrians, then the city can do something about that. Let me just briefly go into some of the things I've highlighted as I went through it. One concern on the exemptions on, this is in section 151.03, general requirements, where it lists exemptions on subsection 1 under B, applicability. One of those is the illumination of streets and roads. I've seen a lot of overlighting, excessive lighting on streets and roads that it seems to be a hazard to driving because of the glare gets so intense at some times. And I don't know how much is required by FDOT, but certainly I think that should not be automatically exempted from the ordinance. And it also exempts lighting solely for signs, but I think as we talked about, we've heard the complaints about that sign or signs downtown, that could be, if we redo the sign ordinance, those aspects of signs I think would be appropriate to bring in that kind of offensive lighting. I like that in both of these, they pretty much exempt temporary lighting, of course, for the seasonal lighting, as well as the low voltage landscape lighting, which is rarely offensive. If it's usually directed down at the plants and all that, and so that's usually a very appropriate kind of lighting use. I do like the way they mention in the ordinance that lighting for architectural purposes to enhance the building, the shape or the form of the building is a plus and is allowed, because I think sometimes creative lighting can make a building look much more pleasant. They pretty much seem to prohibit the same kind of things, the searchlights, aerial lasers, that type of thing. And they both seem to deal with a mechanism to create special circumstances or to give special permits, which I think is important because in something as complicated as lighting, there may be circumstances that it might not quite fit within an ordinance. We can't foresee everything.
Right.
And so I think that's important to have that kind of a procedure. I didn't notice in either one, I think especially in option 2, I didn't see where that it applied to anything that the city would be doing, any projects of the city. I'm not sure about option 1, which it does. Do you know whether either of these would apply at all to any city projects?
Historically, well, option 1, I believe, would apply. Well, let's see, under the exemptions. That was something that I kind of went back and forth about. I know option 2 does not. It actually has a list of allowances for things like when you have nighttime construction, it allows for
Blinking,
Public
flickering, yeah.
Works to be able to illuminate the areas. When we did the Mears Boulevard intersection, that was a nighttime project that had lighting there. As far as option 1, let's see.
On page 2.
And I guess, Bill, I guess it would be covered under that exemption that you referenced there under B1 on page 2, 15103, as far as you didn't like the automatic exemption that it would give to lighting within the public right-of-way. Now, I know, well, it would, yeah, that would cover that as well because it says a public right-of-way or easement. And I know some of our public areas have easements on them, so those would fall under that exemption.
Okay, so where there's a public right-of-way or easement.
Or an easement.
That the city maintains or develops, they would have to come within the scope and under the specifications of the ordinance?
If that language is changed. Right now, it says that the following are not regulated by this section, which would include lighting within the public right-of-way or easement for the purposes of illuminating streets or roads.
Well, although this is coming in a little bit late for the project that I guess the city is already underway, and along Spring Bayou, there's the public easement for the sidewalk right along the bayou, and I understand that the city has approved putting decorative kind of streetlights along there, right along the water. And I'm sorry we didn't have an ordinance before they got too far along on that.
They won't be super bright lights, though, will they?
I talked to a person about it today. There's 20 light poles. I think they put cones up to show the location, and they will have, according to the Public Works Director, they're going to have a dark sky approved shield.
The shield, I have talked with him also, and he said that would shield the light going upwards, which is good. But I'm concerned because of the level, well, first of all, and of course, this is all theoretical, I mean, it's all moot, all this discussion. But where the light poles are going to be down by the water, and they're up on maybe a 9-foot pole or whatever, they're going to be probably right at the driver's eye level going by on North Spring Boulevard. So, you look across to the bayou, and the light pole will probably bring that light right up to the level of the drivers. Plus, those who operate on the waterways in their boats, and there's a lot of folks in town who do that, lighting that's near the waterway is very difficult, makes it difficult for boat operators to see and to navigate safely. And so that's another concern when you have a lot all the way around the bayou. Of course, we don't have a lot of boat traffic in the bayou, but still, that's a concern. But it's all moot now, I suppose. But I'm sorry that even though I brought it up last summer, that it didn't get enacted in time to maybe be a concern for the city commission.
Isn't there an issue of safety, though, with the public area on the, I mean, that's one of the reasons why it's brought up, isn't there?
That lighting project was initiated by Commissioner Tarpon, is my understanding. I'm not sure, maybe it was safety, I'm not quite sure about that.
It was for aesthetics.
It was aesthetics because
aesthetics category.
I mean, I saw a proposal that was sent to the city, and I don't know if anyone looked at it, but a local architect sent in a suggested design for lighting along the bayou.
Right.
That would be on these low small
bollards.
pedestals, and they would be
Yeah, I
shining
did
just
see that.
directly down on the sidewalk, which would address the safety issues. It would not produce glare that would be in the way of boaters or others, driving by.
Almost residential like you have in your front yard.
Right.
kind of thing.
Yeah, it'd be more landscape type. It would be very low.
Yeah, I did
low
see that.
wattage.
Why wouldn't they do that? I mean, to me, that would be more practical.
Not my project, and you'd have to ask the project
Tarapani
manager.
did
Yeah,
that
Mr. Tarapani.
Okay.
I think, in all honesty, I believe the intent was to carry the theme of the acorn-style fluted poles down to the bayou. You have those on Orange Street and on Tarpon Avenue and others. So,
Well,
I
those
believe
look
that's-
fine in the daylight. Okay.
I don't think that's fair to say that Mr. Tarapani wanted that way. It was a whole board of the commissioners that approved
That's
it.
true.
So,
That's
I mean,
correct.
our fairity to respect out of the board, it was a whole board.
Right.
And the
Well,
safety
they all share the
aspect-
blame. I'll grant you that.
They
Well,
did-
anyways, it's a mute subject now, so.
They wanted consistency, I'm sure, of.
Yeah, they're
what they
using the
want.
same pole, same manufacturer, same globe that we have in other areas of the city.
But they didn't bother to ask the residents what they thought when they took that vote, before they took the vote.
So, Rodney, are you going to kind of synthesize both of these together, or what are you planning?
Well, I think, if I can speak honestly, not being a lighting expert and not having Tarpon Springs not being a city of a sufficient size where we have a staff that's diverse in a lot of these areas that some larger cities are. Option one is very detailed, and it has a lot of standards and ways to measure those. And in my mind, as I went through it, I think being able to find a way to enforce this style of ordinance, would be a challenge for our code enforcement department. But if that's what the board wants to take forward to the city commission, we're more than happy to do that. Option two is something that I think has some similarities to option one. I like the ability for lighting plans and things to be included with the site plan submittal package, so that mounting heights, luminaire wattages, all those things up front, and you have a lighting plan that gives you the amount of lumens that will be generated by a particular development. I think that's something that has been missing here in the city in the past. It is a little bit more user-friendly. It gives
I have to agree with
those I think some standards that are pretty easy to enforce. Actually, some of this stuff as far as illumination levels, I took from the city of Dunedin's lighting ordinance. They have standards, for example, on page 5, that they don't exceed a half-foot candle at the property line adjacent to a residential use, and not exceed 3-foot candles at the property line adjacent to any other use. And so an ability to measure those. But again, all I was trying to do was provide the board with some things to consider, and whatever you guys decide to move forward with, we'll take that to the commission to gauge their interest.
Well, option two is so much more reader-friendly,
I agree.
and it's a lot more understandable. The other one is extremely technical, but I don't see why you can't
Yeah, and that's not to say that you
put
could
both of these together.
Yeah, pick some of the other standards and criteria out of option one and fold those into option two, if that's what the board.
I mean,
like.
you are not leaving out option one anyhow, because it's already included. And that would be up to TRC. I mean,
Well, I think the advantage of option one over option two, and yes, I grant you that option two is a lot easier to read from a layman's standpoint. I mean, of course, I have to reread it a few times. Option one makes some sense. But the concept of option one that I like is the overlays, because there may be certain areas in the city where you would like more ambient light, or wouldn't, it depends on how the uses are in that neighborhood, and that's why I like the option. I mean, either one of these is better than none.
Right.
But I do prefer the overlay aspect of it, where the downtown area might, be allowed a certain higher level of ambient light than residential areas and that sort of thing. Right. But,
so maybe we.
So what's appropriate in one place might not be appropriate somewhere else. And that's
well, I think you ought to put them both together.
Maybe I can develop an overlay map.
Yeah.
With option two
For
that
the
has
different districts.
illumination standards for the more, like you said, the downtown, the more commercial areas versus the neighborhoods as you get further in the western parts of town.
And it could be different in different neighborhoods, though. Different neighborhoods are maybe out where, not as populated kind of area.
Right.
And I think, isn't it the first one, or is it in the second one where there's an amortization of existing lights? So
That's
that,
a whole, yeah.
after some point in time.
That is an option one, yes, and that's something that,
I mean, if there's sufficient time, I don't know if that's going to be a big issue, as long
Right.
as there's plenty
Yeah,
of
it-
time for people to make that change, and you don't require them right now to
Right.
change all their lights.
yes, option one does have an amortization period. Basically what that means, if you have an existing light fixture that is out of compliance, you have a period of time, whether that be, 6 months or 6 years, to phase out your non-compliant fixtures.
And we have enough people that are going to go around.
Well, and
check
that's
that.
and that's yeah,
That's not
Yeah.
gonna-
that's the issue is the actual logistics of
of how you enforce
enforcing
that.
that is
Yeah,
it would
well,
be
that would be a
challenging.
code enforcement
Yeah.
It
problem,
would,
I
but we only
think.
have one code enforcement person.
You got it. Yes.
Yeah, it's very difficult. I think if you put that in, you may find some resistance where you actually make somebody do something, regardless if it's 6 months or 6 years. That's, well, especially during this time, we're going to have people losing their homes because of this insane flood insurance situation. Very possibly. I mean, half the town is in a flood zone.
More than half. It's more like
Say there's
80%.
more- I was gonna say there's more
Yeah.
than that.
I think we're in trouble. Now, does this include underwater lights or?
No.
There's
I
an
mean,
exemption
for the home.
in there for
They're exempted.
pool lights.
No,
Yeah.
I mean for the homes.
Yeah, the swimming pool
Yeah,
lights.
for
are-
swimming pools and that
Oh,
sort of
I'm
thing.
talking about the houses.
Oh,
that are gonna
when
go
they're
flooded. It'll be underwater. Yes, we will have
That they
underwater
come, we won't
lights.
worry about the lights.
Yeah, exactly.
We'll worry about power. We'll be lucky if we have power.
Any other business?
I
think
appreciate, Rodney, I appreciate you pulling this together. I know it took a lot of work to
And
get
honestly,
that.
Bill, we appreciate the guidance because it's something that we feel would be a good thing. It's just the application of the concept. How do you get a set of criteria and standards in that's fair yet effective? And I think that's what we're all striving for.
And that everyone can understand.
Yes.
I mean, that needs to be, whether it's one or two, you need to be able, if you're off the street, be able to
Because
look at-
you're right, Ms. St. Arnold, what happens is they come in to me and they throw this down and say, what does all this mean? And so if I can't explain it to them in layman's terms in a succinct manner, then we kind of lost the battle at that point.
Yeah. We don't want that.
So what I'll do is I'll,
Can I ask one more question?
Go ahead.
Mr. Vincent, you mentioned somewhere about the sign ordinance. Can we make sure that provision, whatever you're talking about, isn't reliable in the sign ordinance? Because you said it would take care of, the sign ordinance would take care of what you discussed, but the sign ordinance isn't in place, right?
I believe what Mr. Vincent is referring to is before you were on the board, the city amended the code to allow hospitals to have electronic message boards. And so we went through a few iterations on that code amendment that allowed the Florida hospital to install their electronic message board. And there's some illumination standards that were put into that ordinance as well as dwell times and things of that nature. And I believe that's what he was referring to.
I wasn't sure what he was referring to.
Well, that and other animated lighted
Right.
signs.
We had somebody else downtown.
I mean,
with one, yeah.
You know, we drive in other communities and see on the highway, and they're very distracting. I think it's a real safety hazard, and I'm sorry the county hadn't done anything about it, but
But is that sign ordinance in place? Did I miss?
Yes.
That is in place.
Yeah, if you
so-
go down Alt
Okay.
19, you'll see Florida Hospital has their.
Oh, I know they have a eliminated one, but I wasn't
yeah.
sure what Mr. Benson was actually referring to.
Yeah.
I guess.
well, the one we were referring to in our discussions was the one that was right downtown.
Oh, right.
That was in one of the store windows, because the
Yeah.
way the sign ordinance is now, if I understand it right, and Rodney can correct me if I'm wrong, is that if you have a storefront, you can put any kind of sign in the window you want. it's inside, and this was a bright, shining one that shines out onto the street.
Right.
And the sign ordinance doesn't have anything to do with it.
Can't address it.
It doesn't address it.
But this does.
Option 2
This covers
does,
it.
yeah, there's
It's in
a
this-
prohibition against that type of sign in the window.
Well, if we get this lighting ordinance passed, it will cover that.
Yes, my understanding, the
'Cause that's
guy was
light.
just leasing it, and it wasn't generating business for him, so he gave it back to the company.
Well, that's good. It's a good thing you
Yeah, took care of itself.
Yeah, okay. Board comments?
I like to, because of the practicality, I don't know if I said that earlier or not, but that's it.
Anything else? Rodney, do you have anything?
What I'll do is I'll kind of summarize your comments in a memo to the city commission, and they'll have a discussion item on this sometime in November, and then give us direction as to what to do next. And
Does our meeting fall that same week as Thanksgiving again?
we may not have a meeting,
All right.
so I'll be in touch.
Okay.
Have you heard anything about the subdivisions regarding the flood insurance? I mean, are they still going forward? I know the one, I'm concerned about the one at the former trailer park because of the proximity.
Mr. Franzese, the actual Biggers Water, or whatever it is, Bigger Waters Flood Control Act only would apply to a home that was built below the base flood elevation. Pretty much every house that was built after, I believe, the early 90s would be compliant with the flood regulations.
Okay.
So Tarpon Key would not be affected by
Okay,
that new
good.
act. It's really your more 80s and 70s and older homes that were built pre-firm, if you will. Those were the ones that are getting hit hard with the flood insurance
Okay.
escalations.
Because we've approved so many projects and have not seen them go through because of the economy and one
Well,
reason.
now I can tell you that there's a lot of interest in building homes. The Keystone Ridge project that was recommended for approval by this board, they were approved by the commission, and they're coming in for site construction permits this week.
Good.
So they want, the ones that have gotten approval want to build. Is the one on Mears Boulevard, Callista K, they've got several buildings under construction. Anclo River Crossings here at the end of Live Oak, that one is, they have 10 lots out there that are going to be under construction here pretty soon. Tarpon Keys under construction. Beckett Way Townhomes, or excuse me, Brittany Park Townhomes on US 19 and Brittany Park Boulevard. Those are under construction. So we have probably half a dozen residential projects that are in various stages of construction at this point. So,
And we got Callista Bay, I heard, is sold out. I heard Callista Bay is sold out.
yes, they're sold out. All 63 units.
Good.
So,
That's fantastic, though.
yeah,
That's great.
it is.
That brings people into, for everything, shopping, everything.
Yeah, it's good for the local economy.
Okay.
Okay.
Entertain a motion for adjournment.
I'll make a motion that we adjourn.
Second.
Okay. We adjourn.